Right, so let's take a look at the more serious end, the meatier end of the non-fatal offences against the person. And we're going to look in this video at section 20 of the section 20 of the Offences Against the Person Act, and that's grievous bodily harm. And I've used this image not to shock, but just to demonstrate that we are now at how serious these sorts of injuries are, and we'll look at the impact of that as a wound and what we mean by wound later on in the video. But the easiest place for us to start is to look at our triangle once again, on our non-fatal triangle pyramid. And we've already looked at the bottom there in terms of the common assault offences, assault and battery, those that are part of the common law. We've looked at the first and the least serious of the statutory offences, section 47, ABH. This video, we're going to look at the second most serious of the non-fatal offences, and that is section 20, or GBH. And I'm going to refer to it throughout this video as either section 20 or as GBH. It's the second most serious of the non-fatal offences found in the 1861 Act. In a subsequent video, we'll look at section 18, but I'm not going to discuss that here. It is an either way offence, and you will all, or should all, hopefully know now that what we mean by that is it can be tried either on indictment or summarily. It can be tried either in the Crown Court or in the Magistrates' Court. And what's interesting is that it carries a maximum sentence of 5 years imprisonment. Now that's the same, oddly enough, as ABH, and that causes us some problems. What we will have to do, and we'll discuss at a later time, is look at the impact that has when we evaluate the law on non-fatal offences against the person. But certainly, having an offence that is far more serious, that carries the same maximum penalty, does pose us some problems with sentencing. But for us, we are now looking at the second most serious offence in the Offences Against the Person Act, and what we're going to do is look at each of the elements that make up the actus reus and the mens rea, stage by stage. And our starting point, as ever, is to look at the definition. It should always be the place in which we start. And section 20 of the Offences Against the Person Act 1861 clearly states, whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any person, either with or without a weapon or instrument, shall be liable to 5 years imprisonment. Now, it's relatively straightforward for us to identify the key elements of the actus reus, and I'm drawing them in here for you. Okay, so we are looking at, when we are showing our liability equation, we are looking at unlawfully, and I'm not going to spend any great time on unlawfully in this video, but we know that lawful use of force would be in self-defence, would be in consent, and might be in the police in the lawful execution of their duties, for instance. So the first element is unlawful. I think we've discussed that, and I'm not going to discuss it any further. But so therefore we are looking at a wound or the infliction of any grievous bodily harm upon any other person. So our key two elements to demonstrate in terms of the actus reus is that a victim has had a wound unlawfully, they have been unlawfully wounded, or that they have had grievous bodily harm inflicted upon them. The second part that we get from here is this concept of maliciously. Maliciously is the word that is used in the mens rea element, and that means intentionally or recklessly. And we'll look at that fully at the end of the video when we discuss the mens rea element. But in short, for our liability equation, when we are trying to demonstrate criminal liability, we need to demonstrate that the victim has been unlawfully wounded or has had grievous bodily harm inflicted upon them. And then once we have shown and demonstrated that, we need to show that the defendant has done that maliciously, therefore either intentionally or recklessly. I'm not going to discuss the defence issue because we'll apply different defences in different videos. If we can demonstrate these two things, we have our criminal liability. So, there's one other thing I want to highlight on the definition and just bring it to our attention, and that's this here. And I'm not going to spend too much time on it in this video, but what will be interesting is the idea of the definition stating clearly any person is different to what section 18 states, and I'll look at that difference and what that might mean when we look at the section 18 video. But just remember that section 20 clearly uses the phrase any person. Alright, so let's look now at the individual parts of the actus reus. We have two main elements. We have either unlawful wounding, or we have the infliction of grievous bodily harm. Now, the defendant is charged with one or the other. If he's done them both, then the prosecution must choose which one he is going to be charged with. Okay? Now, there may be crossover, and we'll look at, again, I'll talk about that in a short while. There may be crossover in which the wound is grievous bodily harm, or the grievous bodily harm could be the wound, quite obviously. But essentially, there are four different permutations that we are able to find liability for this. One is an intentional wounding. The second is a reckless wounding. The third is an intentional infliction of grievous bodily harm. And the third is a reckless infliction of grievous bodily harm. What we, as the prosecution, have to do is to demonstrate which one of those four permutations do we think the defendant has committed. And we have to charge it right. If we don't charge it right and we use the wrong permutation, then the defendant may possibly escape liability. So, when you have a question, a substantive law question, please make sure that you are very clear in your mind whether or not this is a wounding or GBH. And once you have decided that, is to make sure that you clearly state that you believe that the defendant is liable for X. If you think they are liable for both, you choose the most appropriate one. Now, the next thing to consider is what we mean by this phrase infliction. Well, there's no surprise there, as we've seen in other, when we've looked at other offences in the non-fatal offences against the persons series, it means cause. It's another use of the word that means cause. And there are just a couple of things that I want to just pick out before we go on to look at the key elements of the actus reus. GBH can be inflicted either physically or psychologically. We know that since 1997, Burstow has shown us very clearly that psychological harm can amount to GBH. Dyker is a case in which the defendant infects two women with HIV. He knows that he is infected and he persuades them to have unprotected sex. He did not warn them that he was protected. He is guilty of causing grievous bodily harm under section 20. But what the judge says in both Burstow and in Dyker is that infliction means cause. Okay, and it makes no difference whether the outcome is physical or psychological. Infliction means cause. I'm not going to labour and I'm not going to spend a huge amount of time on that, because it's relatively straightforward and it's not going to use a huge amount of your time when answering questions. But just be aware that the normal rules of causation will apply whether it's physical or psychological injury. And furthermore, the injury inflicted can either be direct or indirect. And if you remember, I'm quite happy if you want to use Haystead as the baby dropping case, as a clear example of what we mean by direct or indirect infliction of injury. So I'm going to move on from that. It's relatively straightforward. Infliction means cause. Because now what I want to do is I want us to demonstrate very, very clearly what we actually mean by some of these phrases. What do we mean by grievous bodily harm? Because on its own, it doesn't tell us very much at all. And the definition for what grievous bodily harm is given in DPP versus Smith, which is the 1961 case. And in that case, you'll remember that from a previous video actually, that a police officer attempts to stop a car and the driver of the car has a number of stolen goods in the car. The police officer jumps on the bonnet, the defendant drives off at speed, zigzags across the road, and the policeman ends up falling off and is killed. But what comes from DPP versus Smith is that the judge gives us a very, very straightforward definition of what we mean by GBH. And by GBH, we mean really serious harm. Now, quite frankly, that still doesn't tell us a great deal. So what we need to do is to have some further direction. And these next few cases may help us in some way to come up with what really serious harm means. The first of those cases I want to talk about is R versus Bollum in 2004. And in Bollum, the defendant is convicted of GBH under Section 18 of the OAPA for injuries he inflicts on his partner's 17-month-old daughter. The injuries consisted of various bruises and abrasions, and he appealed against his conviction on the grounds that the judge should have directed the jury that when assessing the injuries, whether or not they were serious enough for GBH or whether or not they were ABH. The judge in the original trial had said that the characteristics, the age of the victim had to be taken into account. The appeal judge says that the original trial judge was absolutely right. You need to take into account the characteristics of the victim when deciding whether or not harm is really serious. Now, what do they mean by that? Predominantly, they mean age. If you think of children or old people, the level of harm is normally going to be less. So, a broken fibula or tibia in a baby is far more serious than a broken fibula or tibia in a 25-year-old man. A broken tib or fib in an old person is much more serious than a broken tib or fib in a 25-year-old man. So the jury should decide and look at vulnerability, if you like. So that's perhaps even a better word, if I could spell it. Vulnerability. How vulnerable is the victim, and does the vulnerability make the harm more serious? So that's Bollum 2004. The next thing that helps us really is Brown versus Stratton, and R versus Brown and Stratton. And Brown and Stratton is a tragic and interesting case, if you like, but two things come from it. The first is that what amounts to grievous bodily harm is objectively assessed. That is, it's up to the jury. And in using the test of the reasonable man, what is really serious has to be assessed objectively. The second is the idea about it can be cumulative. I'll demonstrate what I mean by looking at the case. In Brown and Stratton, the defendant are cousins, and they attack Stratton's father, and Stratton's father is the victim. Stratton's father has been undergoing gender reassignment. He's going from a man to a woman. At the time of the attack, the defendants had both been drinking and went to the victim's house, went to Stratton's father's house, with the intention of beating her up. And the reason they wanted to beat her up is that Stratton's father had come to Stratton's place of work wearing a dress and had caused him some level of embarrassment. Stratton wanted to get his own back on his father by going round and beating her up. In that assault, she sustained a broken nose, she lost 3 teeth, there was swelling to her face, she had lacerations to her eye and some level of concussion. The defendants offered a plea for ABH, denying GBH. And the trial judge says the jury have to assess objectively what we mean by really serious harm. And what they say is that is or can be cumulative. So a number of small, relatively minor ABHs can amount to a GBH. So the fourth area that we need to clarify, and this is straightforward, is that since 1997, as a result from R versus Burstow, grievous bodily harm can include psychiatric harm. If you remember, the defendant, a little bit of a nutter, has a brief relationship with a woman, she ends the relationship, he can't accept the decision and embarks on this campaign of harassment against her over a period of some 8 months. He makes silent telephone calls, abusive telephone calls, he appears at her house, takes photographs of her, distributes offensive cards to her neighbours and sends hate mail. As a result of that, she suffers from severe depressive illness. The court decides that that level of psychiatric harm can amount to GBH. You'll remember that Ireland says the very same thing for ABH, but in this case, Burstow says it can be GBH. So, what is GBH? Well, GBH is really serious harm. That's an objective test, and what can amount to grievous bodily harm might be different for age-related issues. It can be cumulative, and it can now include GBH. Remember as well from the case up here, Dyker, it can also be about the infliction of viruses and things like HIV and hepatitis. So, hopefully that's relatively straightforward. We now know what GBH is, really serious harm. What we need to do next is to look at what is a wound. Because if we don't have GBH, we may have a wound. And the straightforward, simple definition is given in Moriarty versus Brooks. That's an 1834 case. In that case, pub landlord tries to throw a drunk out of his pub. And the judge in that case says clearly that a wound is a break in the continuity of the skin. Now, I'm not a doctor. I think there are 7 layers in the skin, but there are 2 main layers. And I think one is called the dermis and one is called the epidermis. And what this means is that all layers of the skin have to be broken, and blood is allowed to flow freely. It's a nice phrase to remember when you're talking about a wounding. A wound is a break in the continuity of all layers of the skin, and blood is allowed to flow freely. That essentially is the decision in Moriarty versus Brooks of what a wound is. The more famous case, the one that most people use, is the one of Sear Minor versus Eisenhower, 1984. And in that case, the defendant shot the victim with an air gun, and the pellet hit the victim close to the eye. That results in a bruise below the eyebrow and fluid filling the front of his eye. We've all seen that when somebody's eye goes bright red and it looks very, very bloodshot. In court, it was made clear that a wound is a break in the continuity of all layers of the skin. An internal rupturing of the blood vessels is not a wound. So in Eisenhower, it's not a wound. So, internal bleeding would not be a wound. It may be GBH, but it's not a wound. Now I hope you can see the importance of charging the defendant correctly. There are some interesting questions about what is a nosebleed, and is a nosebleed internal, and when does a nosebleed become a wound, and those sorts of things. So that's quite interesting. But in short, what you will have noticed is that there are occasions on which there is overlap between the wound and the grievous bodily harm. Most wounds, or you could have a wound that is really serious. You could have really serious harm that is a wound. But essentially, a deep scratch that requires a stitch might not be really serious, but might fall in to the remit of being a wound. So you've got to be very, very clear when you think about charging or discussing the liability of your defendant. Alright, so we now know what grievous bodily harm is, we now know what a wound is. Just before we go on, I want to just take a very brief look at the joint charging standards. Remember what I said, do not start your discussion with the joint charging standards. As lawyers, we look at the actus reus and the mens rea. Simple as that. The joint charging standards can be used to back up our thought process, but shouldn't be used to form it. ABH, if you remember, temporary loss of sensory function, multiple bruising, minor cuts requiring stitching, minor fractures. GBH takes that up a level. We'll be looking at permanent disability. and that should be permanent loss of sensory function. Broken or displaced bones, and those big bones, so the femurs, our big bones in our body, not the smaller bones. A fractured skull, or injuries that have substantial blood loss. So you can already see that here we've got far more serious injuries, even in the joint charging standards. So let's take a final look then at the mens rea element. We've done actus reus, we know what the act will look like, what is the defendant's state of mind. So in terms of the mens rea of section 20, it must be done, you remember the word that we've used, it must be done maliciously. Well, what does maliciously mean? It means either intention or recklessness, which makes it a basic intent crime. Section 20 is a basic intent crime. And it is the intention or cunning subjective reckless as to the foresight of some harm. The defendant does not have to intend or foresee the actual wound or GBH. If I was to punch somebody in the face and I only wanted just to give them a bloody nose to warn them off, yet as part of that I fractured their skull, providing I can see either intentionally or recklessly that there is going to be some harm, if the result is grievous bodily harm, I will become liable for the section 20 offence. Providing I can foresee some harm, I will be liable for the offence. I do not have to see the actual wound or the actual GBH, some harm. Our case for that is Savage. Well, our case for the intention element of that is Savage. And we already know the facts of Savage, the girl who poured beer over over a boy in a pub, and what happens is that the glass slips, the glass breaks and cuts him. She claims that she only intended the battery, the beer over the head. The judge says it didn't matter, providing that she could foresee the battery, that was sufficient for her to have the intention for the section 47 offence. And you'll remember we called that half mens rea. Well, Savage exists and still exists in terms of the section 20 element, the foresight of some harm. But I'm also going to introduce the joint heard case of Parmenter. So you often hear them referred to together as Savage and Parmenter. And Parmenter is where the defendant is convicted on 4 counts of causing GBH under section 20 in relation to injuries to his baby son. The baby suffers injuries to the bony parts of his legs and forearms, and that's due to the heavy-handed way in which the defendant handles the baby. The defendant's not used to handling young babies and did not know that his actions would result in injuries. The trial judge directed the jury that they would convict if the defendant should have foreseen that his handling of the child would result in some harm, as per the intention element. Okay? So whereas the trial judge directed that the jury would convict if the defendant should have seen that his handling of the child resulted in some harm, even if that was only minor. The defendant appealed, stating that it was necessary to establish that the defendant appreciated the risk, and it was not sufficient that he should have foreseen a risk of injury. And the judge agrees with that. The judge drops the case in Parmenter to an ABH because in terms of the recklessness, this is subjective recklessness. And in subjective recklessness, you'll be aware that you have to foresee some risk and go on to do it anyway. Okay, and in this case, the defendant did not foresee any risk because he was not used to handling children, and he did not know that handling children at all would be risky in the way in which he was doing it. So basically the 2 cases, Savage talks directly about intention and this idea that there has to be some foresight of harm, and Parmenter tells us that there has to be a cunning subjective recklessness. You may hear of something called the Moet gloss. And that Mowat gloss refers to the original case, if you like, and it's a 1976 case, so long before these. And Mowat is the first case that says that there has to be a foresight of some harm, not the actual harm caused. But we use, and we tend to stick now just to Savage and Parminter. Savage deals with the intention element, Parminter deals with the subjective recklessness element. So, almost there. That's the last or the penultimate one of our videos on non-fatal offences against the person. It's straightforward. It's not difficult. Grievous bodily harm is not difficult. It's about the identification of whether or not the injury is either GBH or whether or not it's a wound. And getting that perfectly right using either the Miller principle of really serious harm or the Moriarty versus Brooks and the Sear Minor versus Eisenhower, all layers of the skin being broken and blood being allowed to flow freely. Once one of those two is present, you then only have to demonstrate that the defendant intended or was reckless to the foresight of some harm. If you can do both of those things, you have a clear Section 20 offence.